Hey everybody, my name's Clay Cheshire. It's probably been 6 or 7 years since I've made any YouTube appearances. We did a series of videos with Iraq veteran 8888 years ago and got some interesting feedback. Anyway, I'm one of the attorneys at Munitions Law Group, and we're going to be pushing a lot of content out over the next 6 months. And what I'm going to talk about today is really most of my videos are going to be geared toward licensees, FFLs. They're because that's most of what my practice is. And what we're going to talk about today, and it's something everybody's heard of who has an FFL, is the revocation process now, with what everybody calls the zero tolerance policy that ATF pushed out about 2.5 years ago. I'll talk a little bit about how inspections used to work. So, historically, pre-Biden administration, ATF revoked a very small number of licensees, and if you got revoked, your chances of prevailing, and the way you prevail, you request a hearing with ATF. They'll decide during that hearing whether to let you keep your FFL or whether they're going to go forward with a final revocation. If you do get a final revocation, then you have a chance to appeal it to federal court. But if you got revoked, you had a very low probability of keeping your FFL. And the reason is they typically only revoked licensees that had engaged in the types of behaviors or the types of repeated behaviors that gave them a good case for revocation. What ATF has to prove, and this hasn't changed, this is something that's been in place for pre-Biden administration and post-Biden administration or current administration. ATF has to prove that a licensee willfully violated the Gun Control Act. The standard is not negligence, it's not accidentally, it's willfully. And really the best way to describe willfulness is to say that the licensee knew or clearly should have known, based on other evidence, that engaging in a certain behavior would violate the law, and they did it anyway. That's basically the standard they have to prove. To prove knowledge, you either had a licensee that had a prior inspection, had these same violations pop up 3 or 4 years ago, then they have a current inspection, the same violations happen again. In that scenario, ATF's argument is, hey, look, we've inspected you before, you had these violations before, we talked to you about these violations, you explained to us that you were going to fix them, you told us how you were going to fix them. We came back 4 years later, did another inspection, and found the same violations. That's one way to show willfulness. The other way to show willfulness is with showing that you were educated about a certain issue in another situation, right? And that based on all the evidence, your education standing alone without a history of violations is enough to show that you knew that you were doing something you shouldn't have done and did it anyway. Let's talk about how inspections work now. So under the zero tolerance policy, what ATF did is it identified a number of limited types of violations that, if they occurred even one time, that it would automatically lead to revocation. So in that sense, it's almost a strict liability threshold. And the types of violations, for example, are things like not running a NICS check, and not running a NICS check can come up in a couple of different scenarios. It can be where you just outright forgot to do the NICS check, or you didn't record information on a 4473 that demonstrated that you had run a NICS check and had no way to prove that you had, and ATF has to assume that the 4473 is correct, and therefore you didn't run a NICS check, and they go with that. Or it could be, for example, that you accept an expired carry permit as a NICS exemption. You don't realize it's expired. It may have expired the day before the transaction. It may be that your buyer has a renewed permit, but it has kept a copy of the expired permit and handed you the wrong one. And you know the buyer, and you know he has a permit, but you accept that expired permit. You don't run a NICS check. That's a violation. And that one violation, in our experience, will put you into revocation. So it's strict liability is probably the best way to describe it. And what that did is it shifted the burden. See, what historically has had to happen is ATF has to present evidence of willfulness. What it does now under zero tolerance for those certain violations, it shifts the burden from ATF to the licensee to prove that the violation was not willful. So you're having to prove a negative. The upside, I guess, if you want to call it that, is that with revocations now, because so many of them are based on, zero tolerance violations, and there's not this long history of challenges, and there's not this lengthy, egregious record with lots and lots of violations. The upside, if you want to call it that, is that if you get revoked, in certain circumstances, you have a better chance of winning. Stats are coming out. It will take time to digest them. But from what we can discern, you've got about a 50-50 chance of winning if you go to a hearing on revocation. That wasn't the case before. Before, maybe it was 10%, if that. But I think that when you look at sort of what's happening politically, I don't know that zero tolerance is really about winning or losing revocation cases for ATF. What we think it's probably about is putting pressure on the industry to compress it and make it more challenging to be a licensee. Again, zero tolerance came from the top, right? It didn't come from within ATF. It came from above ATF and was pushed down. And, I think what you're dealing with is you're dealing with the government, which is basically limitless in its power, versus, family-owned businesses, especially when you're talking about dealers and really manufacturers. And, it can easily cost, if you get revoked for a single violation, and you have to go through the hearing process, and you have to hire an attorney, and you have to develop your evidence, and you have to prepare for this hearing and prepare testimony and prepare to talk about the case and review the documents and defend yourself. The cost can easily range from $25,000 to $50,000. It can be more than that, depending on the circumstances. And so for a lot of licensees, they can't afford that. And rather than fight it, they just discontinue voluntarily, surrender their license in lieu of revocation, or otherwise discontinue. And so they're voluntarily leaving the industry. And if you look at the statistics, you'll see that a significant percentage of these revocations under the Biden administration have resulted in voluntary discontinuances, for lack of a better word. So what's happening is you have a policy that is putting pressure on the industry and compressing it. Now you have fewer dealers, and over time you'll have fewer dealers, and it'll be probably noticeable. And it disincentivizes, right? It disincentivizes people who might want to get an FFL from getting into the business. It disincentivizes potential investors from wanting to put capital into a business. It disincentivizes lenders from wanting to make loans, lines of credit to businesses, because it creates uncertainty. You can spend time and an enormous amount of money to build a business, and it can be taken away. The license that it has to have to do that business can be taken away under some strict liability type circumstances. So, what we advise, obviously we have a lot of clients that come to us that we've never met before who are in revocation, and they don't have a choice. But for those in the industry who have not been revoked or have not been inspected, in the last 3 years, we tell them to evaluate the risk, right, and to be very proactive and strategic in trying to avoid revocation in the event that they'll eventually be inspected. So a strategy to avoid revocation. Keep in mind when you're trying to evaluate risk that there are factors that would make a licensee more of a target. For example, if you have a high number of traces, if you are a dealer and you sell firearms and you get a relatively large number of traces in terms of your overall sales, then that can make you a target. And it's not that you've done anything wrong. It just may be that the city you're in or the demographic that makes up most of your customer base, for whatever reason, there may be more thefts of guns that they purchase, and then those guns are used in crimes and subsequently traced. In that scenario, the dealer didn't do anything wrong, but that high volume of traces can put them on the radar screen. Gang-related traces, right? So if you have within your overall trace volume, you have a significant number of gang-related traces, that can also make you a target. The number of NICS denials, right? So if you have a higher proportion of NICS denials than sort of the median NICS denials that are standard for dealers across the board, that can make you a target. Again, none of those sort of bases for targets are themselves indicative of violations, but they do increase the likelihood that you'll have an inspection, and the inspection is inherent with revocation risk, especially under zero tolerance. So here are the things that we advise people to do to be proactive and to be as prepared as possible in the event there's an inspection and in the event they end up in revocation. The best way to create a record that is easier to defend. The first thing, make sure you have an organized employee training program. Take the time to put together written materials or use some of the vendors that provide online training materials, and make it a practice to put new employees through that training and current employees, on some sort of a periodic basis, twice a year, quarterly, whatever works best for you. But have some thoughtful training. Invest some time into creating some policies related to training. Develop some SOPs, right? So, these don't have to be long and detailed, but you can have, 7 or 8 different SOPs that are specific to the risks that are most relevant to your business. And the SOPs are really designed to fill in gaps that may exist in, for example, if you have a software, right? So I'll give you an example. One of the NICS violations can be accepting an expired carry permit. So if you use a software-based 4473, that software is not going to catch whether the permit's expired or not. It's going to that transaction is either going to succeed or fail based on the date that the user puts into the software. So if your employee or a buyer puts a wrong date on a 4473, the software is not going to stop that. So an SOP might be something that says that anytime someone is presenting a carry permit as a NICS exemption, that you specifically check the expiration date on the physical permit against the date that's on the form. That's an example of an SOP that would fill in a gap that may not be covered by software. So do SOPs. Put them in writing. Again, if you ever get revoked, we're going to present those SOPs as an exhibit to show how proactive you are, and that it's hard to be willfully violating the Gun Control Act if you are creating SOPs specifically to avoid violations. Do internal audits, right? So periodically, whether it's quarterly, monthly, twice a year, whatever sort of fits your business the best, do internal audits. And what you're doing, you're reviewing your 4473s, you're reviewing your A&D record, you're reviewing, and what you're doing is you're checking the effectiveness of the training and the effectiveness of your SOPs. You're identifying weak points. You're identifying potential weaker employees that can then be retrained. You can adjust your training. You can retrain employees. You can move them to a different role. But it shows, again, that you're doing this ongoing evaluation of your operation to identify compliance challenges and addressing them before ATF catches them. Catches is the wrong word, but before ATF's on site and discovers them, you've discovered them yourself. Do periodic inventories, right? Have a written process, and this is inventories of your firearms inventory. Have a written process that's designed to make sure that you are checking what's on the shelf to your A&D record and from your A&D record to the shelf. And what you're really doing here is you're trying to identify potential missing firearms. If you have missing firearms, then you're obligated to submit a theft loss report to ATF. And, if you're not doing periodic inventories and aren't catching things, then that can create a pretty major compliance risk for you. Compliance software, right? So, 8-9 years ago, there were software was, I would say, a relatively new phenomenon, and it wasn't sort of an across-the-board approval for ATF to use, for example, a software-based A&D, and now it is. And there's some really good products out there, and the software will, for example, you can have these products that integrate with your entire point-of-sale system that are designed to again, you have this software-based 4473, which is, generally speaking, you're not going to be able to, for example, if something's blank or if an item is checked yes, that would normally require that the transaction not happen. The software is going to prevent the transfer of that firearm. It's not going to let that 4473 go through. So it's a good way to minimize the risk of mistakes. 4473s are what create the highest risk of revocation because there's so many opportunities to make mistakes, and the zero tolerance, the NICS-related zero tolerance violations are probably the ones we see the most in terms of leading to revocation. So, the 4473s create risk. If you're going to do them and you get a software-based 4473, you'll reduce that risk just by virtue of getting that product. And then, the A&D also. I mean, the software will basically, when a 4473 is approved and a transfer happens, then there's going to be an entry made in your disposition record. So it ensures these timely disposition entries. Again, the compliance software will help you, again, minimize the risk of certain violations. I guess the last thing I'll talk about is, it helps if you can point to a history of being cooperative with law enforcement or ATF. That doesn't necessarily mean calling them. It just means, having written policies, for example, that you train your employees on to say, look, if you're uncomfortable with transferring a gun to somebody because you think they're under the influence of drugs or alcohol or don't seem right, that you can deny the sale. If you have suspicions that you may be dealing with a straw purchase, as an employee, you're free to deny the sale. Do that. If you've had things that were lost in transit and you work with law enforcement to try to find it, those are good things. That's a good record if you can show that because keep in mind, ATF's primary objective, spoken objective, is public safety. And so if you can show that there's a record of you doing what you can to keep the public safe, then again, it creates a better case for you if you end up in revocation. So that's all I'm going to talk about today. I hope that you heard something new that you haven't heard before, and we'll do more of these videos that are geared toward licensees. And I don't have a tagline or a byline like Derek does, but have a great day, and we'll talk soon.